Hi, welcome to Tozen Daigaku. This edition of Tozen Daigaku will focus on the bare bone basics of Japan's Trade Union Act. I often translate it as labor union law. It's労働組合法. My name is Louis Carlet. I'm senior organizer and chief finance officer of Tozen Union. And so let's get right into it. I'm first going to share document. I can't prepare in advance. This is really the core of union rights in Japan. Okay, so let's start at the beginning. So can you see the file I shared, Oren? Can you see it? Can you see it? Just to make sure. Okay, great. Okay, so as you see there, it's the Constitution of Japan. Nihon Kempo, actually, I think it's Nihon Koku Kempo. Okay, that one. Nihon Koku Kempo. This is the Constitution of Japan. This was promulgated after World War II. And the key article I want to look at today is Article 28. Article 28. 勤労者の団結する権利及び団体交渉、その他の団体行動をする権利はこれを保障する. Okay, so the Constitution of Japan guarantees the right of workers to organize and to bargain and act collectively. Okay, so these are called together the three fundamental labor rights. Okay, or in Japanese, the Rodo Sanken. We'll talk about that a little bit later, but this is the core of union rights in Japan, and this is the basis for the Trade Union Act, which is in the next slide. It's not really a slide, but next page. Okay, this is Rodo Kumiai ho. Rodo Kumiai ho, it's officially translated as the Trade Union Act. Like I said, I casually translate it as Labor Union Act. And we will get to some of the details of the Trade Union Act soon. But these also discuss the three fundamental labor rights that all employees in Japan enjoy, except government employees, and that's one of the exceptions. Okay, so these are called the Rodo Sanken. Now, what are the Rodo Sanken? So in Japanese, they're called Danketsuken. That's the first one on the top row, and that's the right to solidarity. Now, what does, well, let me go through the three and then I'll come back. So first, the right to solidarity. The next is Dantai Koshoken. That's the right to collective bargaining. And then the third is Dantai Kodoken, which is the right to collective action, like including strikes. So let me go back. Danketsuken. Okay, so these three are not equal. The three labor rights, the Rodo Sanken, are not equal rights. The core of all the rights is Danketsuken, the right to solidarity or unity. And I grew up in the United States, and so I think there's kind of a cultural difference between the word solidarity and danketsu, at least my impression or my experience. Now, the law takes this word very seriously, danketsu. In fact, it's illegal to violate workers' right to solidarity. I don't know, like in English, it seems that solidarity has a kind of like an abstract or esoteric sense to it or something like that. In Japan, it's a very real thing. And one of the manifestations of how real it is that, like, for instance, the right to collect dues or the right to submit dues is part of the right to solidarity. In other words, workers have a right to band together, to work together, to improve their conditions. They have the right to share some of their assets. In other words, this is dues. So this is something that we at Tozen Union, sometimes we have inquiries or people trying to, who want to join. And some people, I mean, because of the society we live in, tend to sometimes think of dues more as fees, sometimes fees for a service. In other words, you pay the labor union and then the labor union provides you some service, protection, they help you out, they give you advice, you know, like a transaction. Now, it's not transactional. I mean, especially in the law, there's no sense in the law that there's a transaction. Dues are not in exchange for something else. All they are the members expressing solidarity and deciding to pool their resources into a collective kitty and then use those resources together and decide how to use those resources together. So this is a really, really fundamental thing in Japan, this right to solidarity. All those actions, coming together, meeting together, supporting each other, sharing funds and resources, sharing an office, all these things are part and parcel of the right to solidarity. And this right is constitutionally protected. So what we try to tell people who are just coming in or don't have that much experience of unions in Japan is that there's no fee. These dues are something that the members each year decide how much dues they're going to submit each month. And it's still their money, and it's just their collective money, that amount of money. And there's nothing, it's not like the member is paying something and then the union is a separate entity. The members are part of the union, and the members together, they hire organizers, they hire lawyers, they rent an office together. And so they support each other as part of that solidarity. So this is something really fundamental. And this underlines all the other two Rodo Sanken. Okay, so let's go to the other two Rodo Sanken. And again, everything goes back to Danketsuken. Employers cannot violate your right to Danketsuken. In other words, they cannot interfere with your right to recruit the union, to build a union, to talk to your fellow employees about your working conditions. A lot of employers don't want you to tell your coworkers how much money you earn or how much your contract pays or how much your bonus is, but you have this right to solidarity. Okay, so based on that right, as a dantai, as a collective, you have the right to dantai koshoken. This is the right to collective bargaining. This is the second one here. I think you can see the shading there. Okay, now collective bargaining. Okay, normally, the way the law sees an employee-employer relationship is, okay, so let's say you see a job ad, you answer the job ad and you say, and it says, okay, we're gonna pay you $200,000 a month. And then you can either take it or leave it, and you go to the interview, and let's say they offer you the job. Now, you could counter propose. What you must understand is whenever you see a want ad or whenever a company offers to hire you, and they say, this is what your contract is, 250,000 yen a month, one bonus in the winter. That's actually a proposal. You don't have to agree to it. Of course, you can counter propose and say, no, I need more than that. I need this amount. I need 300,000 a month. Now, of course, the reality is in most cases, if you say that, you're not going to get the job. So, but what is technically from a legal point, what is happening is that there's individual negotiations. And again, the most 99% of the time, employer says, we'll offer you this, and then you take it or leave it. That's the negotiation, so-called, right? So it doesn't seem like a negotiation. It seems like you're just agreeing or not agreeing to what they unilaterally said. However, that's technically an individual negotiation. Now, why is it that an employer can offer you something and you basically can't effectively negotiate back? If you say, I want more, basically they're going to ignore you and just look for someone else. Well, the reason is because there's an extreme imbalance of power. And this is also how Japanese law sees it. But what the phrase you hear is economic and social imbalance of power. The company has a lot more money than you have. They have all these people asking for jobs. You are one person, you have to make a living, you have maybe a family and children. So there's a complete imbalance of power. Now, the law, trade union law, actually understands that. And trade union law, and in fact, the Constitution that we looked at, the Article 28, one of the purposes of this, in fact, the main purpose is to redress that imbalance. So, right, like without this, company has all the power. You take it or leave it. And of course, then, wages are going to go down, down, down. It's going to be a race to the bottom. So this trade union law is a check on that race to the bottom. It's an attempt to redress, to some degree, the imbalance of power between employer and employee. Okay, so one of the things they do is they save the right to solidarity, the first right. The second thing they the law stipulates is that you have the right to collectively bargain rather than just individually bargain, you and the company where you're very, very weak. I mean, no matter how talented you are, if the company can survive without you, right? Okay. And it's not, and lots of people have a lot of skills, but if you combine your collective strength, your negotiating power into a collective, you have a lot more negotiating power. Your negotiating position is much, much stronger. And so the law recognizes that right. And what that right means is that, okay, not only can you unionize based on the right to solidarity, you can get together, you can have meetings, you decide together what demands to submit, and then you submit the demands to the employer and you say, look, we're not going to negotiate individually about this. We know the limits to that. We know our negotiating position is weak individually. We're going to negotiate together. We're joined together. We've combined our interests, even though some of the workers have different conditions and different situations. We're going to combine our strengths, support each other, and accept or not accept as a union. If you make a proposal, we're going to go back and negotiate and discuss and maybe vote democratically, and then we're going to decide whether to accept your proposal or not. And by the way, we're not so happy about what we agreed to when we first came in. You offered us 200,000 each. We accepted it because we need a job and we have families to support, but now we're going to ask more. We want a pay hike, okay? Or we want better conditions. We want more safety at the workplace. Or with Corona, we want online lessons because we don't want to, constantly ride the trains to work and risk infection. Whatever the members want, they decide together and they collective bargaining. And of course, they have much more success in getting better conditions because there's a little bit more balance. Still, employers in most cases still have most of the power, unless you can recruit every single employee, then that you might be on an equal footing. Okay, so what if you negotiate and the management, okay, first of all, they have an obligation to meet you for collective bargaining. So they can't just say, no, we're not going to negotiate with you collectively. We'll continue to negotiate individually. They can't say that. They have to agree to collective bargaining. They have to meet you. And not only that, the law doesn't say it explicitly, but case law says they have to negotiate in good faith. In Japanese, it's called sei o motte koshou suru. What does good faith mean? Okay. So in other words, they can't just show up to the meeting room or now the Zoom room and just sit there with their arms folded and just say, nope, 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 nope. Whatever you say, they say no. They can't do that. They have to make some effort to answer your questions. Okay, you say no, why no? Why can't you give this 10% raise? Well, okay, because look, this is our finances, right? Look, you can see we've been bleeding red ink for 3 years. And if we give you a pay hike, we'll go bankrupt, okay? They have to explain. Not only do they have to negotiate and answer your demands, if they say no, they have to explain. And it can't just be like, no, we don't want to, or no, because we hate you, or no, because, we're just in that mood, or, what often I hear employers say is no, because there's no need, or no, because we're not breaking the law. These are all common answers, but that they must negotiate in good faith. They must make an effort and they must explain whenever they say no. So if they refuse a pay hike, okay, tell us why. And if it's financial, then show us the finances. If they don't show the finances and they just say, well, we don't have the money and don't explain it, that can also be a violation of the law. And we'll get to that a little bit later. Okay, so collective bargaining is the core, it's the main road of all industrial relations in Japan between unions and companies. One thing I've learned over the years as an organizer is like whenever you get stuck in a certain situation, you can't seem to break through, collective bargaining is always the right answer. I don't think I've ever seen a time when the right answer is not to do collective bargaining. And a lot of members say, why are we collective bargaining? They never agree to anything. They just, they're just showing up. And Okay, well, that shows a record of them not negotiating in good faith, and that shows that the union has tried to resolve it before we resort to a little bit more aggressive means of getting what we want. And that brings us to the third right, Dantai Kodoken. And this, of course, is probably the right that you hear about a lot in the media. Dantai Kodoken. This is the right to collective action. And this includes, in fact, the main collective action that's protected in Japan is the right to strike. This is a real core right in Japan, protected in the Constitution and in trade union law. Countless court cases and verdicts and precedents uphold this right to a very high degree. This is something, again, to use my own country as comparison. In the US, there is the right to strike, but there are many, many exceptions. And one thing that happens in the US is that sometimes courts will order workers back to work. They kind of interfere with this. In Japan, it's a pretty sacrosanct right, although there is an exception, that's government employees, and that's a whole nother issue. But all other workers, all other employees have a very strong right to strike. And it's not just to strike, it's any collective action. It has to be legitimate. There are rules, and there's kind of a lot of case law about what is acceptable and what is not acceptable in terms of how you strike or do direct action, leafleting, public campaigns. You can do all this as long as you do it according to certain procedures and rules and laws and stuff like that. Like, for instance, for a strike, one of the rules is you can't strike without trying to resolve the issue in collective bargaining first. So you can't just submit the demand and the next day go on strike. That would be an illegal strike, which is really not a good idea. And it could be even criminal. You have to try to negotiate first. That's what the courts have been saying. And you have to notify the company, we will go on strike. However, one thing that the courts over the years we've seen is that there's no time minimum about going on about notifying the strike. So you can notify 5 minutes before the strike starts. Oh, by the way, our members are going to go on strike in 5 minutes. And court cases have actually upheld very similar cases, but you do have to notify them. And there are certain rules, like you can demonstrate at the company, but you can't block people from coming to work, like people who aren't part of the strike. You can't block customers. There's kind of a lot of basic rules like that, but fundamentally you can put down your tools, walk away from work, walk away from the classroom, and go on strike. Now, the purpose of the strike must be to realize the demands that you negotiated over. Okay, so you can't strike about something else. You can't strike about demands you have not submitted. You can't strike about something outside of the company's control. So in Japan, it's illegal to do sympathy strikes. General strikes are technically illegal, although if it happened, I don't know how they would enforce it. You can't strike for a political cause. You can only strike to realize the union demands. Okay, so these are the Rodo Sanken that everyone in Japan should know, whether you're Japanese or foreigners. And by the way, foreigners have these same rights, just as Japanese do. Okay, let me go to the next one. Okay. Now, so what if the company doesn't do what they're supposed to do? What if they violate your right to solidarity? What if they refuse collective bargaining? What if when you strike, they fire you or demote you or cut your pay or harass you? What then? Okay, these are what's called unfair labor practices, or in Japanese, futororokoi. The unfair labor practices is probably the most misunderstood word in all of labor nomenclature. Unfair labor practice is not what it sounds like. Like when I first heard that word, I thought, oh, something a company does labor related that's unfair. That's not what it means. It's a weird technical word that has a very specific meaning. It's specifically applied to violating trade union law. In other words, if you violate labor standards law, that's not an unfair labor practice. It might be unfair, but it's not an unfair labor practice. It's illegal and it violates Labor Standards Act, but because it doesn't violate trade union law, it's not an unfair labor practice. If a company has poor safety, if there's workplace safety doesn't meet legal standards, that's not an unfair labor practice. So I really want everyone to understand what unfair labor practices means. It means a violation of trade union law, period. And this is the same in the United States. This is a word I'm pretty sure was borrowed from the United States, basically a direct translation. Okay, so now there's two articles in trade union law that if you know them, you basically know everything you need to know about trade union law. Article 7 and Article 8. I encourage everyone just to read these articles. They have English translations, and I translate a little bit here. And they're both pretty short. The number 8 is really short, and 7 is reasonably short. Learn Articles 7 and 8 of trade union law. Okay, so Article 7 has 4 parts: 7.1, 7.2, 7.3, 7.4. What this is things employers cannot do. Your boss, your employer cannot do these 4 things. And I want to go over them because when they do these things, a union can appeal to the Labor Commission to try to overturn it or to punish, well, not really punish, but in order to stop the company from doing this. Okay, so it's a good idea to know what 7.1, 7.2, 7.3, and 7.4 are. Okay, so this number 7.1 is the basic one, is that they can't, your company cannot disadvantage you for union activity. They can't, let's say you're recruiting at your workplace, you get people together, you declare a union, you ask for collective bargaining. They can't say, okay, we're going to cut your pay now, or we're going to fire the leaders, or we're going to fire everybody, or something like that. They can't discriminate against you for that, okay? And they cannot make non-union status a condition of employment. These are called yellow dog contracts. In other words, some companies are so brazen, they put in the contract, you can't be in the union, or they ask at the interview, are you in the union? Or they say, you can't be in the union if you work here. All that's clearly illegal, okay? So this is 7.1. Now, they can't make non-union status a condition, but they can make union status. In other words, if the majority of the workplace is already a union, then they can sign an agreement with the union, which is called a union shop agreement. And a union shop agreement means to work there, you have to be in the union, okay? So that they can do. And they also can pay union members more salary than non-members. In other words, discrimination against union members is illegal, but discrimination against non-union members is actually legal. And the thinking, I think, is that, well, union members are really working together to improve their conditions. So, and if they make an agreement, that can apply to them if they want. So that's a very important, again, these are all designed to redress the balance of power. Okay, let's go to 7.2. 7.2, the employer cannot refuse collective bargaining without a good reason, okay? So the union decides what demands to submit. They submit the demands and they ask management for collective bargaining. We want collective bargaining. So management says, no, we don't want to negotiate with you collectively. Okay, so that's, in principle, that's illegal. That's an unfair labor practice. Now, without a good reason. So what is a good reason? Well, what is a good reason is we're not the member's employer. And it sounds funny to say that, but actually a lot of workers don't know who their legal employer is. So that's something I encourage all members and all workers to make sure you know who your employer is and to know the name in Japanese if possible. Okay, so one legitimate reason was we're not their employer, or we haven't been their employer for 2 years, or let's see, or every time we do collective bargaining, one of the members punches the boss or something like that. These are something that could be legitimate reasons to refuse. Now, if there's something that's not clear which way, then the union can go to the Labor Commission and sue the employer for refusing collective bargaining without a good reason. And then the Labor Commission has to decide, was it a good reason or not? One thing that Tozen Union often gets into trouble with is, not in trouble, but one issue we often face is language. Because although many of our organizers speak Japanese, we often want many of our members speak English, and we want the collective bargaining, or CB as we call it, we want the CB to be in English. And often if management is Japanese, they'll use this as a way to refuse and say, no, it has to be Japanese, or we're not going to do it. Now, one of the things about CB rules is that they can't be decided unilaterally by one side or the other. The union and management are equal when it comes to collective bargaining. So all the rules, where, when, how, what language, recording, no recording, all these issues must be discussed in good faith between the two sides and agreed upon equally from a position of equality. So if management says, no, we're not going to negotiate unless it's in Japanese, and the management says, and the union says, come on, let's talk about this, then that could be unfair labor practice refusal to negotiate collectively. Okay, we've had many cases related to language. We also had a case where we had a company based in Ibaraki Prefecture, and our member was in Yokohama and our office in Tokyo, and they insisted that they'd only do collective bargaining if we went to Ibaraki, and that's far away. It costs a lot of money for each member that would have to go up there. The worst thing is that the members' workplace was in Yokohama, and the company had an office in Tokyo, so it was really unreasonable. We knew that the management spent some time in Tokyo, and so it would have been very easy for them to come to Tokyo, negotiate with us, and not try to force us to go to Ibaraki. We knew it was just an obstacle that management was putting before us to make it hard to realize collective bargaining. So we sued in the Tokyo Labor Commission and said they're refusing collective bargaining without a good reason. We won, and then we had negotiations in Tokyo. So there, in many cases, there are ways to resolve these issues. And again, collective bargaining, management must do it, and rules must be decided equally. Okay, so let's go to 7.3. 7.3 is the most esoteric and abstract of all the 4. Number 3 is called Shihai Kainyu. Let me write this in Japanese. Shihai Kainyu. Okay. The Shihai Kainyu literally translated means dominate, interfere. Okay, but that's kind of like, what does that mean? Okay, so Shihai Kainyu, this is 7.3, is management cannot they cannot screw around with you. Okay, so let's say you form a union and management doesn't cut your pay, they don't fire you, they don't fire your members, but they make the members' lives miserable. Very short-tempered. They invite everyone else out to for drinks, but not the members. We had one case where, at least if my memory is correct, they had what's that thing called, the bubble tea thing, where they had like a bubble tea party, and they didn't invite the union members. Really bizarre. They can't, or like a lot of companies, they'll stop greeting the union members. Like, they'll be nice to everyone else and just really cold to the union members. They'll try to isolate them. They'll try to get non-members against the members. Or we've had one place where many times in Tozen, we have a case where the employers tried to divide Japanese and foreigners from uniting. And so since they're often Japanese employers, they'll appeal to the Japanese. And so we had one case where an employer told the Japanese secretaries at a language school to be really mean to the president of the labor union, which was a teacher, So all these things are kind of like on the level of harassment or non-tangible discrimination. You know, they don't cut your pay, they don't increase your work hours, but they do all these other things that makes work miserable, or the bad environment, or makes them feel very uncomfortable. This is all called shihai kainyu. Well, this is the kainyu part of shihai, the interference. They can't make you wish you were not in it. Another thing is they can't do is they can't try to control the union. They can't get involved in your operations. They can't try to convince some of your members not to strike. Like, let's say there's a vote and the members are voting whether we're going to strike or not. Management can't start pulling aside each member and saying, I don't think you should strike, you should vote no. They cannot interfere in the election. This is very different from the United States. Let's say there's an election, there's a more militant faction and a more moderate faction. They can't actively or openly support the moderate faction. They have to stay out of it. They cannot interfere or try to dominate or control in any way. And if they do, they're violating 7.3, which is called shihai kainyu, and the Labor Commission, if you go through the Labor Commission, they will order the company to stop doing that. Okay? Now, those are the main three. Now, 7.4 is much rarer. And basically, you can't disadvantage workers for petitioning the Labor Commission or for testifying in the Labor Commission. Because let's say a worker who's not in the member, but did see the management do something against a member, that worker, she might testify in the Labor Commission just what she saw. Now, management might really hate her for cooperating, and they might try to, do something to her or isolate her or fire her. They can't do that. That would be a violation of 7.4. So all of these are called unfair labor practices if the company does any of these things, okay? Now, one thing I want you to understand is that this is all employee-based. Before you assume you have these rights, make sure you're an employee and that management recognizes you're an employee. One thing we often see is what's called gyomu itaku, which is outsourcing or individual service providers. In other words, some companies or language schools, they don't even recognize the employee status of their workers. They say that they're, kind of like individual service providers, gyomu itaku, like private businesses. And it's just a business to relationship. Now, if that's true, then you don't have these rights. Or let's say you do IT work on a freelance basis from your home, and there's no set work hours. It's just they give you a task, you do it, you get paid. That's probably a legitimate gyomu itaku, and you don't have these rights. These rights are all for employees, okay? What's called rodosha. Okay, let's go to the next slide. Okay, now the other article in Trade Union Act is Article 8. Now, Article 8 is very, very important because let's say you exercise your right to strike. That's collective action, one of the three fundamental rights guaranteed in the Constitution. And your union, let's say 5 members go on strike. And because of that, the company loses several contracts worth millions and millions of yen. Let's say 10 million yen or something like that. Now, if the strike is legitimate, then you're protected. Even if the company loses, 10 million yen because of your strike, they cannot claim damages. That's just that's just the rules of the game. And a strike does sometimes cause damage, even though that's not the purpose. However, many companies, of course, their first instinct is like, they're causing us damage. We lost that contract. We're going to sue them. We're going to sue the union. We're going to sue the employees. Nope, they can't sue the union. They can't sue the employees. Excuse me. They can't fire you. As long as your strike is legitimate and you've done it in the proper procedures, you're protected from any damages through court due to your actions. So that, of course, is crucial because otherwise nobody could ever strike because it often does cause damage. Companies often do lose money. Now, the only way they can sue you is if they claim that the strike was illegal. And some companies do that. even when it's not illegal, they claim it as a desperate way to stop the strike. And like the unions have been sued. I personally have been sued for supposedly being part of an illegal strike, although the court case came out in our favor. So this occasionally happens. But if you do things right, don't worry about it, because even if you're sued, you have the law on your side. And sometimes companies sue just to harass the union or something like that. But Article 8 protects you to the extent that it's a legitimate strike and that you're an employee. Okay. So let me go back. So yeah, I think that's good. Okay, so I'll talk a little bit more, but I want people to start sending in questions. Any questions you have? I'm not sure how many we have with us today on live stream. Please send any questions that you would like to hear. And because this is something that so many workers that I talk to through inquiries or the phone lines, so many workers don't know their rights in Japan. And many workers even believe that it's natural for a company to want to fire workers to strike. What a strike is fundamentally refusing to give your labor in a collective way. And again, to strike, you have to be part of a union. It's part of everything is based on solidarity first. But many workers don't realize that they can strike and still be protected. Now, the one thing that if you strike, management doesn't have to pay you for the time that you're on strike. So that they definitely can deduct that from your salary. If you strike for 1 hour, they can deduct 1 hour's pay, but they can't deduct more than that. They can't in any other way disadvantage you. So let me ask Oren, do we have any questions? How do you want to do this? How do you want to do this?
I'll ask you the questions.
Okay. And then maybe I should repeat them so people can hear them or something like that. Is that okay? Okay.
So far that we've got 3 questions.
Okay.
First question, is there a law about mentioning union news to other workers while on company premises?
Okay. So the question is there a law about union news while on company premises? Okay.
To other workers.
To other workers, yes. That's a good question. Okay. There's no specific law. Okay, but basically, well, first of all, check to see if there's any agreement between the union and the company that deals with this. That's the first thing to look at. If there's no agreement, or if it's a new union, then basically you have the right to recruit coworkers. Okay. Now that right is not unlimited. You should do it when you're not actually working. So like on breaks, when the other worker is not actually working. So, and do it in a way that does not interfere with either of your work. Okay. So if I'm working with Oren and we both work, but we have the one time, like 10 minutes where we're both on break and we go to the coffee machine and I say, and let's say Oren says, hey, Lois, we're thinking about joining a union. Do you want to join? And I'm like, no way. I don't join these crazy things. I'm not a communist. And so I push him away. Now, neither of us have broken the law, and management cannot retaliate against either of us. We've just had a discussion. He can ask me to join and he can try to recruit me, and I can refuse or agree. However, one thing I would say is that another thing is you can do is Oren could go outside of the workplace, outside the building, and when people get off work or on their way to work, he could leaflet, say, hey, join the union. We're making we're forming an Acme union at Acme, so all workers at Acme should join, and he could pass out leaflets. I wouldn't do it inside the workplace. Okay. And that actually, just like workers have 3 rights, management also has 3 rights. And one of the rights that they have is called Shisetsu Kanriken, and they control the facilities. They control the workplace, the building, the rooms. So they can tell you don't leaflet inside. So, you can't stand there and leaflet, or you can't make big speeches and stuff like that. But you can definitely talk to your workers at the water cooler. You can definitely reach out to your coworkers and say, let's join a union. You can email them, text them, blah, 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 like that. Okay. Hopefully that answered the question.
Next question. How long did it take to sue the company in the Ibaraki CB case?
Okay, that's a good question. Okay, I hope I get this right. Okay, so in the Ibaraki CB case, it was an ALT dispatcher. We sued in the Labor Commission, and the whole process, including testimony, I think was about a year. Jerome, I don't know if he's here now. Jerome would probably know more about that, but I think it was about a year, which is actually short by Labor Commission standards. And the reason it was relatively short, I know a lot of people probably think that's not short at all, but the reason it was only 1 year was because it was a very simple, straightforward case. Management refused unless we went to Ibaraki. So management was unilaterally imposing CB rules without our agreement and in effect refusing. So the Tokyo Labor Commission said, nope, you can't do that. Don't unilaterally impose conditions. And then we ended up having CB. So yeah, it takes a year. Justice grinds slowly in Japan, very slowly. And that's something that very difficult for foreigners who are often, passing through or not here long. But that's something you got to know in Japan, things take a lot of time. Courts even longer. So.
Okay. Unrelated question.
Mm-hmm.
Is the union concerned about vaccine mandates in Japan?
Mm-hmm. Okay, so the question is the union concerned about vaccine mandates in Japan? Now, I'm assuming you mean employers who force their workers to take vaccines. I'm assuming that's what it means. Because I don't think the government has any plans to force the citizens to take vaccines. So assuming that's what you mean, that some companies might force their employees to take vaccines, as is happening in the United States. Now, the union currently has no position on that because it just hasn't been brought up, and the members will decide if they want to fight that. In effect, each local union will decide if that happens, that local union will decide whether they want to fight against that or not. And we've had a lot of corona-related issues that locals have fought with, like I said before, about online versus in-person classes. So let's say Acme Company, tries to force all its employees to take vaccines, and we have a lot of members there, and maybe they're mad and they don't agree with the mandate. Maybe they support vaccines but don't think it should be forced. Maybe they are okay with it. I could even imagine some locals demanding that it be mandated. So there's all kinds of possible opinions about this. My opinion about it is not important. Tozen currently has no official position. What I would say is the local union will decide what position they want to take and to what degree they want to fight for it. I hope that answered that question.
Okay. It seems that the limitations of contract length, e.g. 5-year law, is a major trump card for any company to remove members and union trust. Is there any recourse or method for securing or recontracting union members or protecting employees with just non-renewing everyone?
Yeah, that's a great question. And the 5-year thing refers to Article 18 of labor contract law, which was and in 2013, the law was revised so that any worker on a fixed term contract who is employed more than 5 years can switch to permanent status. And at the time, me and a few others were very concerned that management would, instead of it improving job security, it would hurt job security because management would purposely limit contract length to 5 years, either with 5 1-year contracts or a 3-year and a 2-year contract, or 1 5-year contract, which is the maximum fixed term contract. And in fact, that has happened in many places. Now, what I'd say is there's no legal recourse. In other words, if they do that, and if when you walk in the door, they say, okay, 1-year contract, but up to 5 years and you're out. And it's very clear from the beginning, and it's on the contracts and the work rules. There's no way you can win in court to force a 6th year, okay? However, if you build a strong union and if you have good solidarity and you go through the collective bargaining process and you fight, you could win job security by forcing the employer to start letting people stay beyond the 5 years, and then you convert. So it's really up to workers and worker solidarity. One thing I've learned is that lawyers, like government agencies, the law, none of this is as strong as if the workers, the employees are really together and really determined to improve things. That if they can do that, they're much stronger than any lawyer. They're much stronger than any government agency. They're much stronger than the law itself, as long as they work within the confines of the law. So I would say in the situation you described, I would say that the only recourse is to recruit early, build a strong union at the very beginning, and then negotiate, and then fight, and try to push management to accept an extension beyond 5 years.
Next question. With the corona situation at the moment, how much does being involved with a union cover the safety of family members being exposed to virus that are high risk? For example, is a union member able to collectively bargain in regard to protecting the safety of family members of the union members in such a case?
So I assume you mean because if they catch COVID at work, they'll go home and infect their family members. I assume that's the basis of this question. Now, under the law, the union can only negotiate directly for the members. So the family members, unless they are members and work there, unless they're employees of the company, the union can't directly negotiate on behalf of family members. However, of course, workplace safety is a very important thing. There's laws about it. And even if the laws are being complied with, the union can demand greater safety. And like I said before, we've had workplaces, including universities, where the members demanded that they teach online, especially whenever there's a corona surge. And so in that way, they're able to protect their family members. However, the management has no obligation, at least, the management has no obligation to negotiate about non-employees, even if they are members. So the union can only negotiate for its members, and management only has to talk about its own employees. So I hope that answered the question. And if anything I say doesn't answer the question, or you have a follow-up question, please feel free to do so.
I have a question myself.
Okay.
What's a good way of initiating organizing your workplace? Earlier you talked about sort of what you can and can't do really in the workplace, but what would be a good way of initiating the organizing rollout, maybe?
Okay, so Oren's question is, what's a good way to initiate union organizing at the workplace? Now, first of all, caveat, like I'm an organizer, but I'm not like, I don't have any particular skill in recruiting my coworkers. I have organized a union before, but many of our members are much better at recruiting coworkers than I am. All I can tell you is things that I've seen work and I have ideas about it, okay? So first of all, of course, it depends on what kind of workplace you work at. Do you work at a factory or do you work at a school? Do you work only online? And of course, COVID has changed a lot of this. So the first thing is to understand your conditions. How, some employees don't even have contact with other employees because of the online situation. So if you work at a regular workplace where you come into contact with your employees, the first thing I would say is build friendships. Like get to know your coworkers, get to know their hobbies, where they're from, what they like, what they don't like, their background. Really get to know them and really build relationships of trust where they trust you as a friend. And then in that context, I would say, talk about your working conditions. Some people are really like, they don't want to share their salary with their coworkers. They're very nervous about that. And I think management really tries to inculcate that feeling. But if it's, don't push your coworkers, but if they're open to it, ask them about conditions, and be forthcoming about your own salary and conditions, and ask them what they don't like. I mean, it's very natural for workers to bitch about their boss, right? That's like, there couldn't be anything more natural and common. Go out, if you drink, go out drinking with them. If you, whatever hobbies, if you have similar hobbies, and on breaks, talk to people, find out what your coworkers really care about. Really listen to them. I mean, maybe one of the best ways to recruit is to listen to your coworkers. And then when you decide to broach the subject, first of all, you can broach the subject of labor law and trade union law, and just so they know, like no one's just going to jump, or not knowing, but very few people are willing to just jump in without knowing anything. So before you even broach the topic of joining, you can talk about the Constitution of Japan, you can talk about trade union law, you can talk about what other unions are doing, you can talk about, and then you can say that if you want, you can say that you're in the union. One thing is never talk to management about the union ever, but you can talk to your coworkers, especially ones you trust, and say that you're in the union and treat them like a member before they're a member. Tell them what's happening. If you and others are already in the union and there's all kinds of things going on, tell them the story of what's going on. And then maybe every week give them an update. And the more they hear about it, without any pressure, I think they get more interested in it, and more they start to more identify it. Yeah, like I hate when they do that too, I hate how they don't even open the windows during class when we're in the middle of a COVID surge. I really hate that. And just talk about it. And then it should come naturally and organically, I think. That's my experience. And again, I have no particular skill, even though my job is an organizer. So I hope that answered your question, Oren.
Thank you. Next question has a bit of a setup to it.
Okay.
My visa period is for 1 year. I would like to engage in new activities at my current workplace, but I am afraid that I will be hired away because of this, and that my term
be what away? I'm afraid what?
Like hired away, or maybe like moved.
Oh, moved. Okay.
And that my contract will not be renewed.
Mm-hmm.
No matter how much the right to organize is guaranteed in the Constitution,
yep.
In the case of foreigners, it is not really equal because of the shackles of status of residence, is it?
That's right. That's right. Is that it?
Yeah.
Okay. Yeah, you're exactly right. Despite the law being neutral on the issue of Japanese versus foreigners, the questioner is 100% correct. The stakes are very different for foreign workers, okay? So it's important to understand that. One of the things I do in every labor consultation is, if the person I'm talking to is a foreigner, I'm always sure to ask, when does your visa expire? Because that's crucial information. The first thing I want to make sure is that we protect that person's ability to stay in Japan. So one thing I say is understand when your visa is up. And another weakness, of course, is the 1-year contract or fixed term contracts, because that puts you in a very weak position if management decides to non-renew you, especially if it's near your visa. So understand all these things. However, one thing I want you to understand is that joining the union is not the same as declaring your membership to management. Again, never talk to management about the union individually. Only the union talks to management. So never directly talk to management. Only talk to coworkers you can trust that they're not going to go run off and tell management, Orange in a union or something like that, right? So first of all, join the union. Any coworkers you can get that you trust, join. But of course, we talk about it, our organizer will talk about it, and just don't declare until you're in a stronger position. Maybe after you get a 3-year extension of your visa, after you've converted to permanent employment, or after you just got your new 1-year contract, after you've got several members, because if there's, if you have a lot of members, it's less likely the management is going to try to retaliate. And then, of course, don't forget it. If it's illegal for employers to non-renew you because you're in the union. Of course, that doesn't mean it doesn't happen. It does happen, but it is illegal. Know that. And join first, get people together, build yourself up, and then declare. We have local unions or local members who are in the union for years and years without management ever knowing about it. We have an entire local like that. So there are two different things. Join. We also, on our website, and Oren is the PR director, so on our website, we have pages for certain workplaces. So let's say, okay, you work at Acme company, right? So we can set up an Acme union, just call it an Acme union. Doesn't have to have your name on it, doesn't have to have anyone's name on it, just Acme union. So if you work at Acme, please contact us. And that way we can try to build up our strength before we decide to declare and negotiate. So I hope that answered.
Next question. This is another one that's a little bit maybe off topic. Can or does the company have the right to insist that workers submit photos for internal use? For example, Berlitz has said that they have to provide a photo for their MS teams.
Okay, so this is a tricky question. First of all, in principle, everyone has a right to their own image, which is called shozo-ken in Japanese. However, in the context of employment, it depends on what the contract says and what the work rules say. And on top of that, it also depends on whether it's a legitimate, there's a good reason for it. So there's no way to answer yes or no easily. If it's in the contract and if it's in the work rules and if it's a reasonable thing, like Berlitz, I'm not, I can't personally judge whether it's legitimate or not, but then they can do it. If it's not in the contract or the work rules and it's kind of ridiculous, then they can't do it. The main thing is they can't do it without your permission. So if you're already employed, let's say you're already employed permanently, and then they say, okay, we want to use your image, please sign this release. You don't have to sign it. If you're employed in a job security, then they can't fire you refusing something new, like a new agreement they're proposing, or you could also negotiate something for it. So in principle, you have the right to your own image. And then after that, it's the contract. Like if you sign a contract, then you agree to the contents in principle. So hope that answered it. Is that it?
Essentially, yeah.
Okay.
Next question. In my past workplace, there was one employee who would attempt to work with management and snitch on other employees, then claimed harassment when we ignored them. Is there any recourse or protection for, like, when an employee is actively working against each other and trying to side with management and union when we are trying to organize a union?
Yeah, so kind of like a management lackey or a scab. So, well, I mean, you said non-union. So just to be clarified, if they're in the union, then there's definitely a lot of things we can do because they're violating solidarity within the union. One of the union's cores is that you cannot act on behalf of management. If there are coworker who's not in the union, there's a limit to how much you can do because it's not illegal for a worker to be pro-management or to be friends with management or anything like that. So I would say just the social pressure, if more and more workers are in the union, then it might help to isolate that person. But I can't think of anything, at least that directly, that you can do to try to stop that management from going off to management. I would say also don't tell the management lackey much. Don't tell them that you're in the union. Don't talk about the union or what the union is doing, and keep the firewall that I think you described.
Just to clarify the previous question about the image thing, the company wants to use it just for internal use,
Mhm.
as the person's aware, for like Microsoft Teams or
Yeah, so this is about the question about the image, and they just want to use it for, say it again, for what?
like MS Teams?
MS Teams? Oh, like video meetings?
Yeah, potentially.
Yeah, so if it ever came up in court, the judge would have to decide, is that a legitimate use of it? Is it gori teki, which is like, is it reasonable? Again, like, I mean, I can only guess what the result might be, and it might pass muster, but again, you have to agree to it. So is it in the contract? Is it in the work rules? Is there some release that you signed? All these are questions that would come up in court.
Be all of the questions.
Okay. Okay, great.
Okay.
Well, thank you very much, everybody. If you're not in the union yet, please join Tozen Union, bring your coworkers. And if you are in Tozen Union, please recruit your coworkers. You have to build up solidarity at the workplace, solidarity being the #1 right of the Rodo Sanken. And thank you very much. Bye-bye. And our next, sorry, before I go, our next Tozen Daigaku is, will be on, oh, Hori to Hanrei. That means legal principles and court precedents, which is what date?
The 10th of October.
The 10th of October. So we'll send out, our president will send out emails with the notifications. So thank you for coming and talk to you later. Bye-bye.